So you can't deport me out of this. I'm an American citizen. I have rights. How dare you, judge? They say, shut up. Close your gym down. You conspiracy theorists. Close it. And so for the foregoing reasons, the government invokes the state secret privilege and hereby declines to further respond to the court's minute order. You don't have the power to get these materials, nor is it in America's interest to give you these materials. So go back to your chambers and pout if you want to, but you're not getting them. President Trump, Pam Bondi, and others now invoking the state secrets privilege. This is a fun one. Of course, this is the case involving the deported Tren de Aragua terrorists. Trump classified them accordingly, but not all of them got deported. Some of the people who are actually suing Trump to stop the deportations, the return to El Salvador, are still in the country. And of course, the case is called JGG et al., keeping the names of the Tren de Aragua people pseudo-anonymous, lest their identities be stolen. But what has happened is they sued, and the judge granted their demands, saying that Trump cannot continue these deportations. And the judge was doing this inquisition, demanding answers on why Trump didn't return the plane. Remember, the plane took off. The judge said, you can't do this. Plane was already in the air. Trump said they were already across state waters, not in the United States anymore. And so we're turning them. They're gone. Bye, judge. Afuera, out of here. The judge says, well, you should have called them and told them to turn them around, and so on and so forth. So the judge said, give me answers on that. Who made those phone calls? What time, was the plane up? Who was on the planes? How'd the process work? Where'd they land? Blah, blah, blah. Give me answers, said the judge. Now Trump is responding and saying, no. How about no? These are state secrets that you don't have access to. We are a co-equal branch of government called the executive branch. This judge is not in charge of us. The Constitution delegates to us certain items that we are responsible for. This judge is trying to interfere and usurp that, so we are not going to give it to you. Here's how it sounds in writing. It says, all right, listen, judge, this is in response to the order to give us information. Trump and the DOJ respond. They say, look, the executive branch hereby notifies the court that no further information will be provided to you, Judge Boasberg, in response to your minute order based on the state's secret privilege and the concurrently filed declarations from the Secretaries of State and Secretary of Homeland Security. It's Rubio and it's Noem. Coming up, we got their declarations queued. They say, listen, Boasberg, this is a case about the president's plenary authority, right? It's broad. It's all encompassing. It's his. It comes from Article 2 and the mandate of the electorate. That's us, the American people. And it's also reinforced by longstanding statute to remove from the homeland, this power, designated terrorists participating in a state-sponsored invasion of and a predatory incursion into, which is into our country, the United States. The court, Boasberg, you, judge, has all of the facts it needs to address the compliance issues before it. You know what's happening. You don't need to go in and ask when we took off and landed and who was in charge and more. Further intrusions on the executive branch would present dangerous and wholly unwarranted separation of powers harms with respect to diplomatic and national security concerns that the court lacks the competence to address. It's not set up for this. The courts are set up to be courts. The executive branch is set up to execute the law. Accordingly, the state's secret privilege, judge, forecloses further demands for details that have no place in this matter, and the government will address the court's order to show cause tomorrow by demonstrating that there is no basis for the suggestion of non-compliance with any binding order. And remember, the judge also scheduled an update. The order to show cause in the law, it's like getting called down to the principal's office. Oh, you're busted. You got to come talk to me and explain why you should not be suspended, son. Not that that ever happened to me, but you get in trouble, explain yourself or else next steps. And that's what's happening right now. The judge has issued that order. The president of the United States is a party to this lawsuit. They're suing Trump specifically. They say President Trump is the only person who alone composes a branch of government. Supreme Court said that back in 2020. One person, right? Article 2 says it is vested in a president, not an office of the president. And some people get this wrong a lot. Even I've heard Chuck Grassley get this wrong. We love you, Chuck. It's not in an office of the president. It's in an individual. That's the point. Says, consequently, this court owes President Trump high respect. They do, and they are not showing it to him. And that came from a Clinton case, 1997, right? The judge said, show Clinton some respect in his cigars. That binding command on this court ought to, but to this point has not informed the conduct of the entire proceeding, including the timing and the scope of discovery, right? This is the president of a co-equal branch of government, the most accountable branch of government, arguably, of all of them, because it's all vested in a single individual every 4 years. The whole country stops to vote for that person. So show some respect, Boasberg, who's not elected at all. Constitutional confrontation between the two branches should be avoided whenever possible. They said that in the Dick Cheney case in 2004, saying the separation of powers doctrine requires that a branch not impair another in its performance of its duties, right? Courts don't hurt your co-equal branch. You're on the same team, Team America. You're not supposed to be insurrecting the operation of the government officially from your dark robes. Judicial deference and restraint are required to avoid undue interference with the executive branch. Nixon versus Fitzgerald, 1982. This is necessary, Boasberg, to avoid the current collision course in which a single district judge, you, James, has unnecessarily put himself in an awkward position that includes the difficult task of balancing the need for information in a judicial proceeding and the executive's Article 2 powers that they're entitled to under the Constitution. So in this case, invocation of the, quote, absolute state secret privilege prevents the court from colliding with the executive. Sorry. In the District of Columbia in 2007, there was another case that was sealed and another case in 1982 that said the critical feature of the inquiry when we're debating these things about whether the court needs this info and when the plane take off and all that crap, the question is not the balancing of ultimate interests at stake in this litigation. It's whether the claim of privilege is more important. The state secret privilege is a common law evidentiary rule that protects information from discovery when the disclosure would be inimical to national security. The privilege may be formally invoked by the head of the department, which has control over the matter. The government need only establish that the requested information, what this judge wants to know, poses a reasonable danger to secrets of state. The issue is whether the challenged disclosures may harm, right? May, not will, or poses a reasonable danger, doesn't need to meet some standard of like beyond a reasonable doubt that it will cause harm. It's just may. It's a lot lower standard than probably what this judge is going to interpret it as. Let's see. Now, judicial review of the invocation is limited. Okay. In other words, once the executive branch invokes it, it's like the Uno card, whatever that one that you can't reverse. It kind of ends everything and they drop it and you're like, oh, you little, I can't believe you had that whole time. It's like that. You know, don't ask, you lose. It's over. Don't even think about reviewing it. And the degree of judicial scrutiny varies according to the importance of the information sought. It's limited, right? You can only view this in limited fashion. The court must afford great deference to the executive branch. This includes being careful not to force a disclosure of the very thing that the privilege is designed to protect. Another case said, the district court, like Boasberg, need not have complete knowledge of how disclosure would even affect or cause a security breach. Judge, you don't need to know why it's bad for you. Where there was only a trivial showing of need for the disclosures, in this case, the judge just wants to punish Trump and the executive branch and hold them in contempt, issue sanctions, create an impeachment trap, create a political narrative that Trump violated a judicial order. He deported terrorists. Wow, they're hanging their hat on this one, but all right. And the circumstances of the case point to a significant risk of serious harm if the information is disclosed, and the trial judge, in this case Boasberg, should evaluate and uphold the privilege claim solely on the basis of the government's public representations without an in-camera examination of the documents, right? So think about this like in COVID terms. You sue the government, you say, you're wrecking my life, my business, you're trying to kill us, whatever your claims are, all valid in many instances, would be looked at and scoffed at by the courts. They would just say, well, no, I mean, the CDC says you have to do this. You have to close down or we're going to die or whatever. And you say, well, I'm challenging that. They would say, well, in good faith, we're just going to look to what the executive branch said needed to happen, which is to close you down and deport you from the military if you didn't get the thing, and deport you out of fire departments and police departments and other institutions. You get deported out of those entities. You sue, say, you can't deport me out of this. I'm an American citizen. I have rights. How dare you, judge? They say, shut up. Close your gym down. You conspiracy theorists. Close it. And then if you sue, you get no benefit of the doubt. They're not looking at this like these poor deported gym goers deserve rights or anything. In fact, they look the other way in this case. In other words, during COVID, they gave the government, their fellow executive branch, every benefit of the doubt. The CDC got patted on the back. They said, well, we just defer to them. They said that this is good for America. They said, okay. Well, we're saying the executive branch is saying these people are bad for America and need to be deported. Now the courts are saying, how can you do this without any process? Where was that due process back during COVID? It didn't exist. So the courts are just, the default good faith benefit that they would ordinarily give to their co-equal branch of government because they're on the same team, they're not affording to Trump because they're judicial insurrectionists. So the information sought by the court, writes Trump, in invoking the state's secret privilege, sought by the court is subject to the state's secret privilege because disclosure would pose a reasonable danger to national security and foreign affairs. And because there is no need for this information other than to try to catch Trump, this court must resolve the application based on the declarations submitted with this motion that have come from the cabinet. They say, here's why, Judge. Now, the state secret privilege reflects the reality that it is the responsibility of the executive branch, not the judiciary, to weigh the variety of complex and subtle factors in determining whether to disclose information and whether it may lead to an unacceptable risk of compromise. That came from 1985, another case called CIA versus Sims, right? That's why we have an executive branch, so that it can act with expediency and not be bogged down by courts and committees and process. Trump's execution of his Article 2 authorities, which are of unrivaled gravity and breadth and include managing matters that are related to terrorism and immigration, requires the utmost discretion and sensitivity. You can't come in there. It'd be like Trump going into the judiciary and telling this judge who he can fire and who he has to work with and how he needs to run his courtroom. It'd be ridiculous. As such, when the government invokes the state secret privilege, no competing public or private interest can be advanced to compel disclosure. So you can't challenge us. The Secretary of State's declaration from It's Rubio confirms that the removal of the alien enemies at issue, namely alien members of the designated foreign terrorist organization called Tren de Aragua, said were the product of non-public, sensitive, and high-stakes negotiations with one or more foreign countries. He says disclosure of the information that's requested by the court could cause the foreign state's government to face internal or international pressure, making that foreign state and other foreign states less likely to work cooperatively with the United States in the future. That disclosure would also be viewed as a breach of trust. It would impair foreign relations and the diplomatic capabilities of the U.S. The end result, Judge, if you do this, would be to erode the credibility of the United States and our assurances that when we engage in these negotiations, they will be engaged with in confidence and impede our ability to do this in the future. Other cases have even said public disclosures can diminish the extent to which intelligence agencies of countries A, B, C, and D will cooperate with our own intelligence agencies in the future. They cite the Halcon case for that. They say also, yeah, diplomatic relations is something covered by the state secret privilege, and the privilege, if it needs to be invoked when it otherwise would disrupt diplomatic relations, yeah, in this case, it also recognized that. Diplomatic security is a lawful basis to invoke the state's secret privilege. So Trump continues from the DOJ, writing, moreover, Judge Boasberg, Secretary of Homeland Security Kristi Noem has also established that responding to the court's inquiry, so now she's coming in, so we got Secretary of State, that's one. We got Noem, number two, saying this would directly compromise the safety of American officers, contractors, aliens, and the American public. Judge, this is crazy. You're going to divulge critical means and methods of law enforcement operations about how we rounded up these folks, and you're going to confirm operational details. It's going to cause harm to national security of America and undermine the efficacy of our counterterrorism operations. And disclosure, Judge, would allow others to draw inferences and insight into how future operations would be conducted, and that's not good for national security. Then they would be able to stitch together an understanding of the means and methods that we use, and then they could try to thwart our law enforcement. So courts are in no position to gauge what constitutes an acceptable margin of error. They're not set up for that. We get to set what these policies are and how this works. And so the court lacks competence to evaluate the risks that are associated with this, or the mosaic effect whereby bits and pieces of data may aid in piecing together bits of other information, even when the individual piece is not of obvious importance itself. For example, they say, Judge, look, confirming the exact time the flights departed, right? This judge is like, when did my verbal order, the judge said, turn those planes around, paraphrase. Then after the hearing was over, he went back to his chambers or wherever, wrote up the order. The written order then came out. Trump says, well, after the written order came out, everybody was already in the air and we're not turning around at that point. Judge says, well, I said in court, turn him around, and that's when you should have turned him around. Like I said, now, and I mean now. So go do it. They didn't do that. So he's trying to pinpoint the exact time. Now, or their particular locations at some other time, like when they landed, or where they were in the air, like where were they specifically? Judge like, okay, were they over Texas or were they over El Salvador? That would facilitate efforts, Judge. If we tell you this, then they're going to track our other flights. They're going to know what's going on. In turn, disclosing any information that assists in the tracking of the flights would both endanger government personnel operating those flights and aid efforts by our adversaries to draw inferences about negotiations and coordination and more. And so simply put, this court, Judge Boasberg, has no cause to compel the disclosure of information from the executive branch that would undermine or impede future counterterrorism operations by the United States. We're going to continue to do our job. Thanks, though. And finally, the fact that there are allegations and claims in the public domain regarding issues implicated by the court's questions is not a basis for vitiating the privilege. He's saying, well, the judge said, you posted videos of these dudes being taken out of the airplane. So what's your state secret there, right? You saw them coming out in El Salvador. You saw them being marched in. It's like, it's like rock music in the background, F-16s or whatever, fighter pilots, terrorists, being thrown off the buses. Like, rock on America. So the judge is saying, what the hell? If you can do all of that, why can't you tell me? They're saying, well, that's not enough. Official confirmation of any of those allegations would pose a distinct threat. So there are claims from people who watch these footage, but maybe that footage is not even the real footage, or maybe, whatever. So that doesn't give them operational intelligence. So official confirmation, though, of any of those allegations, if we said, yeah, that came from this and that came from this, that would pose a distinct threat. The fact that that information resides in the public domain does not eliminate the possibility that future and further disclosures can actually harm intelligence, sources, methods, and operations. And so thus, even though some information has been in the public domain, the rest of the information can still be a state secret and thereby privileged. So accordingly, the declaration submitted from Noem and Rubio coming up establish a valid basis for the state secret privilege. We don't need to give it to you. And they're also dispositive. So stop asking any further questions. This is a dispositive notice for ceasing, Judge, any further inquiry into these flights. You're done. Why? Also, there's no need for any of this information. The quote need for the information at issue here is only relevant to the court to help determine how deeply to probe the details and the basis of the government's privilege claim. So you're just trying to examine like what the privilege is for or how far it goes, but that's not needed for this case. Here, because the necessity for that information is dubious at most, a formal claim of privilege will have to prevail. Trump wins by default. You give them the good faith basis, the benefit of the doubt, and they win. Now, the information sought by the court is irrelevant to their claims. The people who are suing to keep the Tren de Aragua terrorists, the gangbanger ACLU lawyers, are going to have their claims regardless of when the airplane took off, right? The only reason they want the information about when the airplane took off is to say you violated the order. That's all. But it doesn't impact their claim. Their plaintiffs, by the way, have not even been deported. So the court has already devoted more time to these inquiries than it did to evidence and argument on the issue of whether a class of terrorists should be certified, and the judge certified them. Class action lawsuits in America by classes of terrorists certified by Washington, D.C. judges in America. Tell your friends that's what's happening. Yeah. Maybe they'll get a big fat settlement and they can all go on vacations to Disneyland together. So in any event, the government has already confirmed that 2 flights carrying aliens being removed under the Alien Enemies Act departed U.S. airspace before the court's minute order of 7:25 p.m. Judge, we already said they're in the air. Once they're in the air, we're not turning them around. We notified you. That's all the information you need. And the government has not contested for purposes of these proceedings that the planes landed abroad. We know that. You're like, when they land, what time? They landed abroad, and that aliens were aboard. They were deplaned. And after the issuance of the court's minute order. Okay, so they're even agreeing. Look, we admit that they were in the air when your order came out, and they landed after your order came out, and they got off the plane after the order came out. So we're admitting we did not turn them around. We could have. Right, that's kind of implied. To have proceeded otherwise and to have turned planes around mid-air, right? This is what the judge is mad about. Why didn't they come back? Without regard to important logistical constraints like fuel availability or foreign airspace restrictions, the judge is like, refuel your plane over the Gulf of America. Bring those terrorists back. We want them here. Especially on the legally infirm basis that the court even retained authority over aircraft operating outside the United States. That would have implicated grave safety risks. And so, Judge, no more information is needed for you to resolve any legal issue brought in this case. Whether the planes carried 1 TDA terrorist out or 1,000, or whether the planes made 1 stop or 10, simply has no bearing on any relevant legal issue in this case. The need for additional information here is not merely dubious, according to case law, or trivial, according to another case. It is non-existent. You don't need it other than to go, the subtext here, to just go and try to incriminate Trump, to sanction Trump. The executive branch violated no valid order through its actions, and the court has all it needs to evaluate compliance. And so therefore, Judge, this inquiry should end. Now, with the utter lack of need for the information that the court seeks, the court must address then. You have no need for this, so you have to address this with that basis. You must address the invocation of the state secret privilege on the basis of the declarations and without in-camera review of the information at issue. Meaning in-camera review would meaning the judge would look at this in chambers, off the record, essentially in private. It's not required as a matter of course in this, so you don't get to decide whether you need it or not. You can't even look at it. The other court and others said if you haven't established a good need, then the court should not jeopardize the security, even by the judge alone. You shouldn't even look at it, Judge. When the privilege involved is based on a concern about diplomatic secrets, courts should not insist upon examining the evidence. That came out in a 2021 case from DC. Courts are not required to play with fire and chance further disclosure, even if it's inadvertent, mistaken, or even intentional. That would defeat the purpose of privilege. So the Supreme Court has also provided that when a judge has satisfied himself that dangers asserted by the government are substantial and real, he need not, indeed should not, probe any further. So that is the appropriate course in this instance. And so for the foregoing reasons, responds, the government invokes the state secret privilege and hereby declines to further respond to the court's minute order. Sincerely, your friend, Drew Ensign. Thank you, Drew. Amazing filing there. From the attorneys out in Washington, D.C., from the Trump DOJ, sending that one off to Judge Boasberg, who we've seen and covered here for a long time, is trying to catch Trump in ultimately an impeachment trap. Pam Bondi sent this one into Judge Boasberg. She said, I, Pamela Bondi, declare under penalty of perjury the following. I am the Attorney General of the United States, and I advise other agencies on how to handle law and legal questions. The purpose of this declaration is to protect the national security and foreign affairs interests of the United States by joining in my official capacity, writes Pam, the formal assertions of the state secret privilege over the information that Boasberg wants, saying the statements made herein are based on my personal knowledge and in my official capacity and on information I've received. Here's what happened according to Pam. Following the public issuance of the presidential proclamation, on March 15, DHS, Kristi Noem, successfully removed by aircraft a number of aliens subject to Trump's proclamation. Those removals were facilitated by the Department of State, its Rubio negotiations with foreign countries. Then in March 18th, the court requested the following information about those removals. The judge says, I'm the president now, and I want to know what time the planes took off and from where, right? Like everything. What time they left U.S. airspace, what time the plane landed, where they landed, whether they made more than one stop, what time the aliens subject to the proclamation were transferred out of custody, how many aliens aboard the flights were based on the proclamation and other sources, blah, 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 right? Everything. This judge's like, I'm in charge. Now they say, no, you're not getting all that. The Secretary of State and Homeland have each submitted a declaration asserting a formal claim of state secrets. Those declarations reflect the studied and well-supported conclusion of each secretary that disclosure, even ex parte, even in camera, would cause significant harms to foreign relations and national security. And so Pam says, after considering all relevant information, including the declarations of Rubio and Kristi Noem and the following independent legal review by DOJ personnel, I'm satisfied, says Pam, that the assertions of the state secret privilege are warranted and supported, and I join their assertion of that privilege. Signed by Pam Bondi, Attorney General of the United States. So that's one. Then we come back and look who's next. It's Rubio. He says, hey, guess what? I'm the Secretary of State. I handle foreign affairs. Now, the statements made are based on my personal knowledge and more. And what I am writing to do is to assert a formal state's secret privilege. As explained, disclosure of the information covered by this privilege would cause significant harm to foreign relations and the national security of the United States. I've discussed with knowledgeable State Department employees the details of this information, and I think that this privilege is appropriate. Here's what Rubio says. In the course of my official duties, I'm aware that Trump issued an executive order labeling terrorists as Tren de Aragua as terrorists, saying they've engaged in a campaign of violence and more. He says, in the course of my official duties, Rubio said I designated TVA as a foreign terrorist organization. He gives us all the authority there. So in the course of my official duties, I'm aware Trump also invoked the Alien Enemies Act, and I'm aware that this lawsuit is about that. Now it says, in the course of my duties, Rubio, I've been informed that this court has ordered the defendants to disclose a bunch of info. Where did they leave? Where did they get there? What kind of lunch service did they have? And all the things. After careful and actual personal consideration of this matter, it's Rubio says, I have concluded that the disclosure of this information could reasonably be expected to cause significant harm to the foreign relations interest of the United States. And so, when the United States seeks to remove individuals from a foreign country, we must negotiate this stuff. This requires sensitive, high-stakes negotiations. They cover sensitive issues. People have to be willing to accept these things. If you compel us to disclose the number of aliens aboard, including what's asked for in the minute order and the reasons they were aboard, that threatens significant harm. For example, if we were compelled, if this disclosure came to light, it would cause foreign states and their governments to face internal pressures, and they're not going to work cooperatively with us in the future. We're going to have less robust relationships, and disclosures are going to undercut the State Department. Foreign states are not going to want to work with us anymore. And when the United States seeks to remove individuals to foreign countries, it likewise must negotiate the logistical details. Those are sensitive. They're negotiated outside the public view. We have to talk about timing and destination. We don't want that information coming out in whole or part. Then they might not want to accept them. It's going to threaten all these confidential matters and damage our relationship with our allies. And so we cannot answer these questions, like what time they took off, the time they left airspace and more. We're not giving you our flight plans, Judge. And likewise, compelled disclosure of that information, says Rubio, could reveal whether an alleged deportation flight touched down in a third country. Neither the United States nor the foreign state to which removal is being made would threaten significant harm. Now, whether a particular flight carried out for a particular purpose is a sensitive thing. Compelled disclosure of that would breach trust, threaten the willingness of other countries who may not even be unaware of the nature of the purpose of the flight and could cause a problem there. It's critical, says Rubio, to bear in mind that removal operations can be, as they are here, counterterrorism operations too. If foreign partners believe that any relevant details could be revealed to third parties, those foreign partners would be less likely to work with the U.S. That impairs the diplomatic relations and capabilities of the United States and threatens to harm our security. Rubio continues, saying if foreign states believe that information sought by this Judge Boasberg could be revealed simply because a lawsuit has been filed, it would erode the credibility of the United States. We have to protect our info. We can't have terrorists suing to get information on terrorist deportation operations. Do you hear how insane that sounds? Again, this threat to the United States extends beyond the removal context. And so importantly, the compelled disclosure of this sensitive information would cause harm to the United States. Even if some of this came out publicly, like we know we deported them, but the details matter. The disclosure of foreign affairs information is vital to the United States. That does not happen. There is a difference between official acknowledgement and informal reports. And so we're not going to confirm or deny the accuracy of any of those disclosures or any of those videos or speculation and more. And so finally, Rubio says, for at least two reasons, the compelled disclosure of the information sought in this minute order threatens foreign relations, even if you look at it ex parte or in camera. First, having a judge look at it is going to be seen as a breach of trust. We are negotiating with these foreign entities. It's our job to do that, not your job to peer over our shoulder. The sharing of sensitive, non-public information with a judge it's not between the judge, it's between our nations, and the people have elected Trump to manage those affairs. Indeed, any order based on this information would lead to public dissection and speculation about the basis for the order, and that increased public dissection and speculation threatens the significant harm that's already been discussed. We're going to have reduced cooperation from our partners, and I declare all of that is true. Signed by, it's Marco Rubio here in the Secretary of State position, writing in to Judge Boasberg saying, I also agree. You're not getting these records. Now, one final submission to Judge Boasberg comes from Kristi Noem, Secretary of Homeland Security. She says much the same, says, I am here discussing with my employees and more what happened. Said, in the course of my duties, I know that Trump issued these orders, and I'm aware that he also invoked the Alien Enemies Act. Now, in the course of my duties, I have been informed that this court has ordered us to disclose all of the details of the flights, Kristi Noem says. After careful and actual personal consideration of this matter, I, Kristi Noem, have concluded the disclosure of this information could cause significant harm to America. Here's why. First, disclosure information about removal flights, including confirmation or denial or speculation, directly compromises safety. Removal flight plans, including locations and the paths and where they land and how long they travel, it's all law enforcement details you can't know. Even where discussing a past operation, disclosing, denying, confirming, or sharing any other operational details would cause harm. This could allow others to draw inferences and insight into how the government works. This is how they did it before. This is how they'll likely do it again. Now, in addition to flight operations, the number of TDA members on a given removal flight would also expose sources and methods, means and methods, and reveal key details about the operations, allowing other people to draw inferences and more. Revealing or confirming this also would allow our nation's enemies to determine how they best can utilize these sources, right? Whether they were removed based on a proclamation or some other power of law. When they bring their challenges and claims, they'll just say, well, this is how they're doing it because this is how they've done it before. And removal operations involving gangs are also similar to counterterrorism operations. If we had disclosed any of this, that would directly help those groups literally avoid capture. Maybe that's what this judge wants. It would also directly undermine the efficacy of American counterterrorism operations. So if we disclose what this judge has ordered us to disclose, there will be significant harm to the United States. It is both true and well known that official acknowledgement of a fact may be damaging to national interest in a way that informal speculation is not. People could stitch together exactly what's happening here. And if we also disclose this stuff, we're not going to be able to work with foreign nations anymore. These are sensitive matters, and we have to cooperate with other countries. There are non-public, sensitive, high-stakes negotiations that must be negotiated, and we can't be compelled to disclose that. If that were to come to light, there would be internal or international pressure about what happened here, and they're not going to work with us in the future. And so if a disclosure were in any way to undercut, even in the eyes of a foreign state, whether it was fair or not, if it casts doubt on them, it's going to impact all of us. And the judge is not set up to manage this. It's not a political body. It's supposed to be. It has become that, unfortunately. Likewise, if you compel us to ask whether we touch down in a third country, that would would threaten significant harm to the United States. Whether a flight may land in a third country is a matter of sensitive diplomatic discussions, and foreign states may not be willing to talk about that, right? Like, in other words, maybe the Mexican government doesn't want to talk about that. Like, well, we kind of let them use that landing strip. But if the people found out about it, maybe they'd be upset about it. Why are you letting the Americans land here to deport the Venezuelans? You know, something like that. So you cannot damage the U.S. relationship in that manner. It's critical to bear in mind that removal operations can be, as they are here, counterterrorism operations. And if we compromise these, they're not going to want to work with us. We can't even be forced to confirm or deny these things. And finally, for at least two reasons, the compelled disclosure also threatens national security. Even if you look at this in chambers, the mere act of giving the information to this court will be seen as a breach of trust. Oh, someone can sue and some hack loser judge can just order it be delivered to his chambers and you have to oblige? Okay, how about we just don't do business with you anymore? Second, as a practical matter, the more widely information is shared, the greater the risk the information will reach the public, even if it is unintentional. We can't trust your seals or your protection. So it may cause direct threats to the United States, and it's going to damage cooperation from other states as well. And so all this is being signed by Kristi Noem, Secretary of Homeland Security. So 3 for 3. Homeland Security, Secretary of State, and United States Attorney General all coming together with shared declarations explaining to Judge Boasberg, you don't have the power to get these materials, nor is it in America's interest to give you these materials. So go back to your chambers and pout if you want to, but you're not getting them.